She shouldn't be. I shouldn't be burying my daughter. My daughter should bury me. And she had a lot to give. So I'm just trying to hold it together right now.
That's the mother of Adriana Smith, the Metro Atlanta nurse who was declared brain dead in February while pregnant. Adriana's infant son, Chance, was delivered by emergency C-section on last Friday. April Newkirk tells 11Alive that Smith was taken off life support on Tuesday. Now the questions and the accompanying ethical debate over what happened shifts to a new arena. Joining us now is Allison Whalen from the Georgia State Center for Law, Health, and Society. Allison, welcome to the show.
Thank you for having me.
All right, let's talk about this case. It's drawing national attention now. What does it reveal about the tensions between the fetal personhood of law and families' rights to private medical choices?
So I think this reflects the broader issues with respect to abortion restrictions and fetal personhood laws throughout the country, particularly with respect to the chilling effect that they have on the provision of medical care for pregnant persons. So despite the fact that many of these laws do not address any of these sorts of situations explicitly, we can see in the case of Adriana Smith the chilling effect that it has on healthcare providers in making these decisions, particularly in emergency situations where they don't have clarity about the laws and the fears of potential criminal liabilities, which ultimately impacts how they make these decisions.
Yeah, it centers, you speak of the laws, it centers around Georgia's heartbeat law, which generally bans abortions after a fetal cardiac activity is detected, roughly about 6 weeks. How does this legal intersects with the end-of-life medical decisions, like removing somebody from life support?
So based on what we know about this case, it seems that what likely happened here is that looking at all of Georgia's laws that deal with pregnancy and abortion, the healthcare providers in this case made the decision, it appears, that they were fearful that the abortion law, or more likely potentially the fetal personhood law in Georgia, could prohibit them from withdrawing end-of-life care from a pregnant person. So as you noted, the abortion law in Georgia prohibits abortion after the detection of cardiac activity around 6 weeks. When Adriana was declared brain dead, she was around 8 or 9 weeks pregnant. So potentially the abortion law would kick in. As we know, the Attorney General later came out and said that Georgia's abortion law did not prevent the removal of Adriana from life support because that action would not be done with the intent to terminate the pregnancy as the law is phrased. However, what is also going on under the surface here that hasn't gotten as much discussion is Georgia's fetal personhood law, which is broader than the abortion law and defines a fetus or embryo from the moment of conception as a natural person under Georgia law. And so therefore, that could kick in potential homicide charges above and beyond the abortion law, because if a fetus is a person, withdrawing life support would terminate that life, and then potentially the hospital could have interpreted that fetal personhood provision as making them subject to homicide laws beyond the abortion laws.
All right, so you mentioned the statements by Chris Carr. What's in your view, what could lawmakers and courts do to clarify the boundaries between the abortion restrictions and other medical care?
So I think what we saw in this case was, the statements came a little bit too late. Too little, too late were these clarifications. And that's what's happening across the country with all of these various exceptions or unclear and vague laws. So certainly one thing that could be done is that the law could be explicitly amended to make it clear that this does, when and this does and does not apply, and that it does not apply for end-of-life issues. However, I think there's still broader issues. For example, in a number of states, end of life, for example, living wills are either suspended in whole or in part for pregnant people. So that's another area of law that likely needs to be changed. Despite the attention given to this issue and calls by some representatives to make legal and policy changes, I don't think in the near future we are going to see any changes, however, with respect particularly to the abortion law, because the Attorney General and the law supporters don't think, as phrased, the law actually requires what happened in Adriana's case. So they already think the law seems to be clear enough. I think we know that's not the case, but given that there's a Republican majority in the Georgia legislature, making movement on the abortion law, I think, is unlikely.
So you think this is like they look at this as a one-time kind of a thing, or a one-off, that generally it covers everything?
Yeah, I think they view this as the abortion law. If another case in Georgia were to come up similar to Adriana's case, they don't think that the abortion law requires the pregnant person to be kept on life support. However, as I mentioned, this is a broader issue, not just implicating the abortion law. So I do think legislative change is needed with respect to the abortion law, the fetal personhood law, as well as laws and policies regarding end-of-life care and living wills for pregnant people. And I also hope, beyond the legislative change, however, that this is going to engender some broader national and state discussions within not only the legislature, but also the healthcare system. So I hope that this will kind of cause hospitals to create policies and think about these situations in advance, because it's possible that what happened here is that Emory University Hospital was kind of caught off guard and hadn't thought about this situation and how it intersects with the abortion law. So I hope at the institutional level, this will engender some policy changes.
Got it. All right. Allison Whalen, really appreciate you joining us this morning. Thank you for your take.